It's time again for the Insiders with Chuck Chvala and Scott Jensen, sponsored by the Wisconsin Counties Association and the Tommy G. Thompson Center on Public Leadership.
Hi, I'm Chuck Chvala, former Senate Majority Leader.
And I'm Scott Jensen, former Assembly Speaker.
And we're the Insiders. So, Scott, we had a lot of decisions coming out, end of session that happens from the Supreme Court, Wisconsin Supreme Court, and even the U.S. Supreme Court. But particularly with the Wisconsin Supreme Court, a lot of important things, a lot of things related to the power relationships of the branches, et cetera. So give me your take on some of these decisions.
You know, my favorite political science professor back in college used to tell us that one of the jobs of the Supreme Court was to draw lines between the powers of the executive branch and the powers of the legislative branch. And clearly, the Wisconsin Supreme Court has been at it lately. They had a number of decisions, most of them leaning towards increasing executive power, but one recently as well for reinforcing legislative power. So on the executive side, they agreed that the Attorney General, when he has a settlement with some legal case, he gets to decide how those funds are spent. They agreed that when Governor Evers did his 400-year veto, that was constitutional within the powers of the executive branch under the state's constitution. But they also said that when the Joint Finance Committee sets money aside and tells the legislative branch, you got to come back with a plan before we're going to release this money and let you spend it, that is the legitimate function of the Joint Finance Committee. I kind of thought they were just going to be consistently adding power to the executive branch because the liberal majority thinks that agrees with Governor Evers on so many things. But it looks like they're trying to figure out where to draw those lines between the executive and the legislative branch.
Well, and I think that to some extent, this court wants to show themselves as not just a particular ideological bent, but they want to show that they are discerning and will actually look at the Constitution and the law, which some of us would consider a refreshing new court. But the other thing that they did, and Scott's right, these are some very significant decisions. If you ever served in the legislature, were on the Joint Finance Committee, as both Scott and I were. But also, the most, perhaps a surprising one for me and for many people, is that the court did not take up congressional redistricting. And I think a lot of people, especially if you're a partisan on either side, you're really surprised. This is something that the court with the conservative majority took up earlier and said, oh no, this is going to stay the way it is. And but what's happened here, I think there are a couple of things going on. Number one, I think the court is reluctant to take something up this late in the decade when there will be redistricting in 4 years. Number two, I think the court is always concerned. Lower courts are always worried about a court above them that might overturn them. And will their decision really have application? And in this particular case, you think of the Wisconsin Supreme Court as the ultimate authority, and they are for Wisconsin law. However, the U.S. Supreme Court can, on constitutional issues, override them. And I think they looked at this and realized that there was a good chance that that could happen. And they did not want their credibility stolen. And with courts, they're particularly concerned about that. They don't have the power of the purse. They don't have the ability that a governor has to use the executive branch to do whatever. They don't have an army. So they're very concerned about these things. So I think what you saw was a really nuanced court that looked at this in some pretty strong and even creative ways to kind of run down the football field and make the moves around people so that they kept their credibility, they kept their power, but they also showed that they were willing to do things which were not always expected of a liberal majority.
Yeah, I think that was the surprising decision of the court this session, right? Is that after we had a Supreme Court race in which $100 million came flying into Wisconsin to decide which we're going to have a liberal majority or conservative majority, and you saw that this can, if we get the liberal majority, we can get 2 more seats in Congress because they will automatically redistrict the maps in the state. And then they didn't take that. And I think you're right about the relationship between the worries from the Wisconsin Supreme Court about what the U.S. Supreme Court might do. They got slapped down a few weeks back on a decision they made regarding Catholic charities and unemployment compensation unanimously by the United States Supreme Court, with Sotomayor, a liberal, castigating the court for its decision on this matter, where there's generally been a national consensus about religious liberty, and that the government doesn't get to decide which religions are legit and which ones are not, which part of who's religious enough and who's not religious enough. So I think on this matter, on the congressional redistricting, they were worried that if they did this, they might get slapped down again by the U.S. Supreme Court. And you're absolutely right. The courts, their power comes from their legitimacy. Their power comes from people's respect and trust for them. And if they abuse that, then the courts lose power over time. So fascinating session, though, of the Wisconsin Supreme Court. I'm sure there'll be more decisions coming.
And more fun. We'll see you next time, guys.
You've been listening to The Insider with Chuck Chvala and Scott Jensen, sponsored by the Wisconsin Counties Association and the Tommy G. Thompson Center on Public Leadership.